Recording. Mm-hmm. Okay, so thank you for joining us today for our talk on protecting innovations in fintech with a spotlight on blockchain technology. We're doing this today as part of the Scotland Fintech Festival, which we've participated in the last few years, and so we thought we'd do it again. But this time, we'll look a little bit more on blockchain specifically in relation to fintech, as well as more general advice. So my name is Pamela Breyer. I'm a patent attorney in the UK and Europe, and a partner of Marks & Clark. And I'm going to talk to you, first of all, about a bit of an introduction to fintech and blockchain and how that relates to patents. And then a bit more detail about what actually might be patentable in those areas. And then Jason, my colleague, is going to talk about trademarks. And he'll introduce himself a bit later on when it comes to this section. So in relation to fintech patent trends, this graph shows the number of global fintech applications that have been published since about 2002. So it's clear there was a kind of gradual rise until about 2008, and then it's been fairly consistently around the 60,000 mark since then. So certainly a lot of interest in patenting innovations in fintech over the last decade or so. And in terms of who is involved in patenting fintech-related inventions, there are obviously a number of financial services companies involved, but also a lot of big tech giants as well, as shown there. And there really is a convergence of financial specialists and technology specialists coming together in this area. And if you look at blockchain players as well, so these are some of the companies that have been patenting a lot in relation to blockchain. And again, it's a mixture of tech companies and those from the financial sector. And in fact, Alibaba is actually by far the biggest filer of blockchain-related applications. And there are, in fact, many Chinese companies filing in this area. I only put up some of the more well-known names there, but there are, it's definitely something that a lot of Chinese companies are looking at. So just as a quick recap, in case you're not so familiar with blockchain, it really came to the fore in relation to Bitcoin, which is a specific application of blockchain. And blockchain is more the underlying technology that facilitates Bitcoin. And Bitcoin came to prominence through this paper by Satoshi Nakamoto. And no one actually really knows who that is, which is a bit interesting. But anyway, they've described a system for peer-to-peer electronic cash system. And we'll explain a bit more about how that works in relation to the blockchain. So this is an illustration about how a blockchain really works. And the circles on the screen represent nodes or computers in a distributed system. So one of the key things is that a blockchain is not controlled by one single point. It's actually distributed over a network, and lots of participants, computers in that network, hold all the information that's on the blockchain and can access it or add to it. So in a little bit more detail then, really it's a distributed ledger. So it's a chain of information that's recorded in a ledger in a specific order. And if you go through an example here, we might have a first transaction recorded on ledger initially in block one, if you like, and there's a mathematical algorithm that's applied to the data in that transaction. And that creates this, what we call a hash. And that hash value then gets used in any subsequent transactions. So when a second transaction takes place, the hash from the first block is used and combined with the data in the second transaction to produce a second hash, which is different from the first and actually contains within it all of the data in the first and second transactions. So they're linked together. And that is added to the ledger above as a different color as shown. And then again, if you have a third transaction, the hash from the second block is incorporated with the data of the third transaction to produce a new hash. And again, that's recorded on the ledger, and so on and so on. So we have these blocks that are all linked together, and that's what forms the blockchain. And some of the key features of this are that we're really creating immutable records, so they can't be changed. And the reason for that is if, for example, someone tried to change the data related to transaction 2, then that would change the hash resulting from transaction 2, which would have a knock-on effect in the rest of the chain. So the hash of block 3 wouldn't match up and the hash of block 4 wouldn't match up because they're all interlinked. So that's really why the records can't be changed. Once they've been created, then there's not really any way of amending them. Another key feature, as we touched on before, was this decentralization. So there's no overall controlling entity. It's a peer-to-peer system, which is distributed over a network. And that has advantages and disadvantages. But one of the main advantages is this visibility and traceability. So at any node, you should be able to access the full ledger and be able to see all of the transaction history and have full visibility of what's happened and full traceability too. So in terms of patent applications relating specifically to blockchain, the number of published European applications has really seen a dramatic increase in the last few years. So much more recent than the rise we saw at the beginning in relation to fintech generally. Of course, blockchain, whilst it's applicable to many fintech applications, it's not exclusively so. It can be applied in other areas as well. So this would include all blockchain applications, not just those related to fintech. And then this next graph shows the number of published applications, European applications, split by the Office of First Filing. So this gives us some indication of where the inventions that are being filed in Europe are coming from. So the largest pillar here is from the US, and then we've got applications filed directly in Europe by European applicants, and then China, and then the UK, and so on. So I guess it's probably, as you would expect, a lot of interest from the US, China, and Europe itself. But what kind of things are people actually trying to protect in relation to blockchains? Really, so far, a lot of the applications have focused on the underlying core technology, the network infrastructure, different techniques to enhance transmission and communication between the nodes of the network. There's also been quite a lot of focus, as you might expect, in relation to cryptocurrencies like Bitcoin and others. But increasingly, we're actually seeing blockchain being applied in other areas outside of the financial services. Excuse me. So in applications like law, supply chain monitoring is a big one, and healthcare, even government voting and registers, which might even be patent registers. All these types of things where you want to create a record of something that cannot be altered and that will stand the test of time. these are the types of applications that are very suited to blockchain application. So in terms of the types of IP that we're going to look at today, here is a list of various types of ways that intellectual property can be protected. But in this particular talk, we're actually going to focus mostly on patents and trademarks, which are probably the most relevant really for the fintech community and for blockchain applications as well. So we're going to start talking in more detail about patents. So in this section, we'll look at why anybody might want to file a patent in this area. What are the challenges in relation to patenting fintech inventions, especially in Europe? We'll look at the hot topics of blockchain that we've already mentioned, and also very briefly, AI. We'll talk a little bit about patenting outside of Europe, and also patent strategy and commercial value, because it's important to know why patents might be of interest and why they might be commercially valuable. So just some basics to begin with. Generally, a patent protects new innovations and new inventions. And they can cover various different things. So it could be devices or processes. So it could be a device like an ATM, or a process like how a transaction is processed over a network. How these things work. What they're made of. So it could be materials or formulations, so that's probably less applicable here. Methods of making, installing, and assembling. Methods of using things. So that could be a method of using a blockchain, for example. And software. So software is a difficult one, because not all software will be patentable, but certainly there is a lot of software that is patentable, and we'll talk more about where the distinction is in this talk. There's also others too. But in essence, if you are granted a patent, you'll be provided with a 20-year monopoly right. And it's quite interesting, it's actually a negative right. So having a patent doesn't actually allow you to make your invention. It actually gives you the right to stop others from making your invention. The question of whether you can actually implement your own invention depends on whether in doing so, you would infringe anyone else's rights. So there can be a crossover here. And we'll talk about that a little bit later on. Usually there's a very strict novelty requirement. So it has to have not been disclosed anywhere in the world before your application. And there are usually other requirements as well. So it usually has to be not obvious in view of what's gone before also. So why might we want to file a patent? There are various reasons, one of which is a competitive defense. So perhaps in the situation I touched on before, if there are competitors doing things, then you might want to have your own patent in case somebody else thinks you're infringing theirs. Maybe your patent might help in a defense. It could be an offensive strategy. So you might want to stop other people and clearly mark out your own territory. It could be licensing opportunities. So it could provide a revenue stream in its own right, even if you're not operating patent itself. And it could be a bargaining chip. So, for example, cross-licensing. If there are overlapping technologies where really you need to have, be able to use multiple patents, then cross-licensing might be relevant. It's also an identifiable asset. it has value. It can be associated with the business and sold with the business, for example. And it also provides some reassurance, or in some cases, it's an essential element that investors in particular are looking for in companies. So that's another one to bear in mind. Okay, so we'll look a little bit more about the challenges for patenting fintech in the UK and Europe. So as well as being novel, there are certain things that are listed as being excluded from patentability. So these are shown here. The underlying ones are the ones that are most relevant in fintech and blockchain related applications. So mathematical discoveries and methods of doing business, and computer programs are all on the face of it excluded from patentability. But there are these words that appear as such. So in their own right, they're excluded, but it depends really what they do, whether there's something that's patentable. The problem is that many fintech conventions relate to a method of doing business implemented in a computer program. And as we have just seen, on the face of it, these things are excluded from patentability in the UK and Europe. But really, that doesn't mean that they are completely excluded from patentability. It really depends on the details. So patent protection may be available if there's some kind of technical advantage or contribution over and above a business advantage, even if the invention actually is implemented in a computer program. And it's worth bearing in mind that nowadays, there are lots of products and processes that are essentially in the format of computer programs, but really what they do are quite innovative and quite technical, and those are all eligible for patent protection. So this is the elephant in the room, really. What is technical? How do we define that? And how do we work out whether something is going to be patentable in the fintech context? So one way of looking at it is to imagine that the invention has maybe arisen as a result of a collaboration between an engineer or a scientist, or programmer, and a business person or a trader or somebody, a financial services advisor, for example. And the key to deciding whether something might be inventive and patentable might be to consider whether it's been contributed by the technical person, if you like, the engineer, solving a technical problem. So, for example, a method for trading shares that may reduce communication overhead in the network would be a technical solution to a technical problem, and therefore should be patentable. On the other hand, if the clever feature of whatever's happening has been contributed by the business person or the financial advisor, then it's less likely that a technical problem has been solved, at least as viewed by the Patent Office. And so a method for trading shares that minimizes market price, for example, would be unlikely to be patentable. So here are some examples. I'm not going to go through all of them, but you'll see that there's some that are less likely to be patentable, some that are more likely to be patentable, and also a whole host that are somewhere in the middle and may be patentable or not. So there is a gray area. Things on the left-hand side that are not patentable are usually things that are fairly straightforward automation of a financial administrative process, where there's nothing clever has to be done by the software engineer in order to make that happen. Whereas on the right-hand side, if there's been a new arrangement of hardware, or the system has been adapted for faster processing or faster communications, that's leaning more towards solving technical problems where there could be a patentable invention. So some things to look for: is it more secure? Are processes done faster? Is there less use of network bandwidth? There could be things external to the process, like raising alarms, operating or controlling other devices. Maybe there's something in a user interface, or something to do with more efficient data storage or improved hardware. Often these things do come about as a result of a technical trade-off. So if there's been some kind of compromise or technical trade-off, then there might be an innovation, a technical innovation. So what does this actually come down to in terms of fintech inventions? Some things in fintech can be quite straightforward to patent. So the physical things like ATMs and payment cards, even cryptographic modules. But if it's something that is purely software, that's when it becomes more difficult. And it really does depend on what the software does and how it does it. So the things we mentioned before, like does it help to improve data security, authentication, hardware operation, etc. Then it could well be patentable. On the other hand, if the invention really does lie, and the clever aspect of what's been done really does lie in a new business method or an administrative feature, then it's going to be very hard to get a patent. There may still be something you can do in terms of looking for underlying technical problems associated with the business process or more subsidiary features, but these would be not necessarily directly related to the clever part of the business solution. So coming back again to blockchain, if we're just applying blockchain or even AI for that matter to a known business process, then that is going to be difficult to patent. What we need to do is look for a novel technical contribution or advantage. And that might be relating to things like the networking of the blockchain, client-server interactions, routing, broadcasting of the ledger, speed and power issues, and racks and power grids. But also, both blockchain and AI are in themselves quite complex technical things. So they use a lot of computing power generally, and they're very memory intensive. And so there may be something in that, some new way of dealing with those factors and overcoming those challenges that could make something patentable. For completeness, really to touch on AI a bit more, there are really two types of patent application that can result from AI-related inventions. One is technical application. So is AI being applied to a new application in an innovative way that overcomes a technical solution? That could be patentable. And there's also a technical implementation. So is there some change, some innovation in the way the AI itself is operating? And that could also be patentable. So a quick look at patenting outside the UK and Europe. The criteria does vary quite widely between different countries. And the US is traditionally a bit more accepting of this kind of patent application. Having said that, in the last few years, it has become a bit harder in the US, but they're not quite as strict as we are in the UK and Europe. So it may be worthwhile considering if your application or your innovation really is borderline in the UK, perhaps the US would be a better use of your money, and maybe more likely to succeed. It's also worth considering where are your markets, both now and in the future. If you're going to have potentially a 20-year monopoly, we need to think about that quite early on. Also, where competitors are, investors, customers, etc. These are all considerations for where it might be worth patenting. And there is a system called the International PCT system, stands for Patent Cooperation Treaty. And that is basically an application process for patents that helps to defer the decision as to which country you actually want protection in from after the end of the first year from filing an application to 30 months later. And it can also defer some costs, although overall it actually works out probably slightly more expensive. But it at least means you can have some breathing space to decide exactly where your markets of interest really are, and potentially to also seek investment and other things, develop your idea in the meantime. So in relation to IP strategy, it's important to have one and also keep it up to date. Don't forget other types of IP as well. We're focusing here on patents and trademarks, but there may be other types of IP that are very valuable in your business, and those shouldn't be overlooked. For startups, it is worth bearing in mind the expectations of investors, etc., because really a lot of investors and purchasers of small businesses really put a lot of weight on intellectual property, and knowing what you have and how you're managing it is important for that. For some software-based fintech inventions, it might be worth just considering US protection. The US is obviously a huge market, and potentially, and maybe that would be something worth looking into, even if in the UK and Europe, it's not really something that's going to be useful. Having said that, the patenting process itself generally takes quite a long time, 4 to 5 years on average, from filing to grant. And during that time, after you filed your application, you can say patent pending. And so that can be quite useful, actually. So even if it's unlikely that something useful might be granted at the end of it, being able to say patent pending for several years can give you a competitive advantage in the marketplace. And I think the last thing is to consider IP funding options. So there is a scheme for conducting IP audits that's mostly funded by the UK IPO. So the UK Intellectual Property Office will pay up to £1,500, and the applicant themselves only has to contribute £500. And basically you can have in total £2,000 worth of IP advice from someone like ourselves to audit your business or your project that you're working on, and to advise you on what IP protection might be available. So that's worth considering as well. Okay, and I'm going to hand over now to Jason to carry on with the trademarks.
Thank you, Pam. Good afternoon, everyone. So my name's Jason. I'm a associate and chartered trademark attorney based in the Edinburgh office. I'm just going to give you a brief introduction to trademarks, as trademarks will form an integral part of almost any credible fintech IP strategy. If I can get the slides to work. Sorry, just bear with me for 2 seconds. Okay, good to go. So, as I said, it's only a brief introduction to trademarks. So we're just going to start off with just having a look at what is a trademark, and then I'll talk about some of the benefits associated with obtaining a trademark registration, and then I'll go over what can and can't typically be registered as a trademark. So the logical starting point, what is a trademark? So a trademark, like a patent right, is a negative right. It's a registered IP right that protects the distinctive components of a brand. So it would typically protect elements of brand that you'd expect it to. So words, logos, stylization, or a combination of all of them. But trademark protection can also be extended to less conventional aspects of the brand, which I'll discuss in a bit more detail later on in the talk. So it confers an exclusive statutory right to prevent others from using an identical or confusingly similar trademark in relation to identical or similar goods and services. After a brand develops a reputation, it's possible to obtain broader rights in a trademark registration, in which case it's possible to potentially enforce your rights against third parties that are taking unfair advantage or causing detriment to the distinctive character and or reputation associated with the trademark. Like patents, they're territorial in scope. So the general rule is a trademark registration will confer protection in the specific country in which you've got the registration. But there are some exceptions to that rule. There are 3 unitary rights that can be obtained, one of which is the EU trademark, which will cover all 27 member states of the EU through a single trademark registration. Unlike patents that have a finite lifespan, trademarks can potentially last forever, provided that they are used and renewed. It's typically every 10 years and you have to pay a renewal fee. Trademarks are also an intangible asset. They can actually accumulate real value, financial value, and they can be sold, licensed, and used as security for lending. So what is not a trademark? I often get typically startups coming to us where they've registered company names and they feel that that gives them some kind of protection in their brands. But unfortunately, a company name, it just secures the company name in itself. And it will not give you a basis to prevent a third party from using the brand element contained in that company name unless you've acquired unregistered rights for use. Same applies to domain names as well. So again, just secures the domain name, and without any use, it will not provide you with a basis to prevent third parties from using an identical or similar brand. And also descriptors. We often find that marketing departments are quite keen to adopt brands which refer to the specific goods and services that have been sold by a business. But from a trademark perspective, that doesn't confer trademark rights unless you've acquired distinctiveness through use. So you want to typically avoid any descriptors which refer to some kind of characteristic of the goods and services that you're intending to sell under the brand. So like most forms, like all forms of IP, the benefits for obtaining protection is control. So a trademark registration will provide you with a basis to prevent, so by way of trademark enforcement or control through licensing, for example, the third-party use of an identical or confusingly similar mark. It's important to note that you will only typically be able to enforce your rights in jurisdictions in which you have a trademark registration. It also secures a filing date to prevent third parties from filing identical or confusingly similar marks that could potentially be used to block your use and later attempts to register a trademark in a particular jurisdiction. This is important because in some jurisdictions they operate on a first to file basis. So if a third party gets in there first, provided that they're not acting in bad faith, it can potentially stop you from being able to, as I said, use or register the mark in that particular locality. One of the benefits of obtaining a trademark registration is it enables you to bring infringement proceedings against infringers, which generally speaking provides more legal certainty and it's typically cheaper to prove than having to rely on the alternative, which would be the common law tools of passing off. Passing off confers rights in confers a level of protection for unregistered rights where you've acquired goodwill through use. It's important to note that in some jurisdictions, unregistered rights aren't recognised. So, for example, in China, so you really do need a trademark registration in order to have any opportunity to enforce your brand. As I said, it is a property right. A trademark can accumulate value, it can be sold, and it can form the basis of a license agreement. Brands are typically the most valuable assets owned by successful businesses. To put this into context, the Apple brand was valued at 206 billion by Forbes in the world's most valuable brands in 2019. Trademark protection can also add value to the business, and it can encourage investment. Potential investors like to see that brands are protected and that you've conducted appropriate due diligence prior to filing trademark applications. They can also be used as leverage to negotiate coexistence with third parties. So in instances where there are similar marks out there, it doesn't always have to end up in enforcement proceedings. It can provide you with a basis to negotiate a coexistence agreement that can be mutually beneficial to both parties. Trademark registration, they can also act as a deterrent. So many businesses have trademark watch services set up. So many businesses will conduct trademark searching prior to using or seeking to register a mark. And then if you've got a trademark registration, that could be flagged up by the trademark search, and that could deter someone from adopting that brand name. So what can be registered? So as I said, there's traditional aspects of a brand that can be protected by way of trademark protection. There's no surprises here. So words, so PayPal, for example. Stylized words, if you've got particularly distinctive stylization, like the stylization in Coca-Cola, which has acquired a reputation enhanced level of distinctiveness over use, you will have some rights conferred in the stylization as well. Logos, you could potentially have a combination of the words, logos, and the stylization. It's just important when you're coming up with a trademark strategy to make sure that you're being very strategic with which elements you protect. So, for example, if you've got a distinctive logo element, you might want to obtain separate trademark protection for the word and logo element, because then you can be strategic with which marks you rely on when enforcing rights against third parties, depending on which element coincides with the third party mark. And it's potentially possible to get trademark protection for slogans as well, although just a word of caution, slogans typically are considered to be non-distinctive and descriptive because they're typically perceived by consumers as promotional statements rather than trademarks. So unless a slogan has inherent distinctive character, it's likely to encounter objections during the examination process. So in addition to the traditional aspects of a brand that you can protect, there's also non-traditional aspects that can potentially be protectable by way of trademark registrations. So colours, I mean, it's going to be very difficult for you to get protection for a colour without any use. Typically, you would have to acquire distinctiveness through use to get protection. Same as shapes as well, provided that the shape doesn't fall within one of three exclusions, you can potentially get protection for the shape of a product. Patterns as well, and position marks. And then it's also possible to get protection for motion marks. So here's an example of the Toshiba motion mark. This was the first motion mark filed in the UK. And then you can also obtain protection for multimedia marks, which are a combination of motions and sounds. Hopefully this works. And then it's possible to get protection for sound marks, holograms, and then there's even the possibility in the future to extend protection to smells, taste, etc. So it's important for you to bear in mind when your brand identity starts to develop, you might want to think about protecting certain aspects of it which consumers associate with your business. So what can and can't be registered? So a trademark needs to be distinctive in order to be registerable. So it's got to be able to distinguish the goods and services from your business from those of another. So when assessing distinctive character of a mark, the examiners will typically assess the distinctive character by reference to the goods and services that you apply for. So the further removed the brand from a characteristic of the goods and services, the more distinctive it will be. So for example, if you were applying for Apple in respect to fruit, that's likely to encounter objections because it's totally non-distinctive and descriptive. Whereas if you were to apply for Apple in respect to computer software, because it's got absolutely no meaning in respect to computer software, that's going to be considered highly distinctive. So these are the three main grounds under which it's not possible to get trademark protection without required distinctiveness. So as I said, non-distinctiveness, where marks are non-distinctive, descriptive, and or customary. And then just going back to the shape example earlier, there are three grounds where if an objection is raised under one of these grounds, it's not possible to overcome them through arguing acquired distinctiveness through use. So that's an instance where in instances where the shape results from the nature of the goods themselves. So for example, if you try to obtain a trademark registration for the shape of an orange in respect of oranges, a shape which is necessary to obtain a technical result, because that form of IP, a technical invention is more appropriate for patent protection, and examiners are reluctant to grant potentially perpetual monopolies for technical aspects of an invention. And a shape which gives substantial value to the goods. And then there's various other grounds under which a trademark will not be registerable, which I'll let you just go through these in your own time. So when coming up with a new trademark, it's really important to think about what aspects of your brand you'd like to protect. As I said, you might want to, rather than just filing the brand in its totality, you might want to have a think about getting separate registrations for key elements of the brand, just to provide you with a wider scope of enforceability. It's important to think about whether it's sufficiently distinctive to satisfy the requirements for registration. As I said, marketing people often like a brand to pretty much say what the business is doing. So from a trademark perspective, it's very important to make sure that you're pushing back a bit and making sure that you're coming up with a brand name that doesn't have a direct correlation to a characteristic of the goods and services. It's very important to conduct trademark searches prior to filing and using a trademark registration. So a trademark search, a full clearance search, will essentially cast a wide net and just flag up any third-party marks which share similarity to the proposed mark. And it just enables us to make an informed assessment as to the level of risk associated with using and registering that mark in a particular territory. If you intend to obtain registration in multiple territories, it can often be very cost prohibitive to conduct full availability searches in all the jurisdictions. So one alternative is to conduct an identical search which can cover multiple jurisdictions. And although it will not give you a conclusive, a definitive answer as to whether or not the mark's available, it will at least enable you to identify any serious and potentially insurmountable risks, and it might push you to think of alternative branding if it's not possible to overcome them. And then, I mean, it's self-explanatory, but it's just important to make sure that your IP strategy aligns with your business plans. So think about timing, budget, etc. You also might want to have a think about where your brand's likely to be infringed and where your competitors trade. There are some jurisdictions where infringement occurs more frequently. China's a good example of that. if you do intend to trade in China, it's very important that you make sure that you get the application on file prior to launching the brand, as we've got multiple horror stories where third parties have come along and filed an application before the legitimate brand owner and then held them to ransom. And it's really important to ensure that you own the IP. So when logos are created, there will be copyright in the logo. If you commission a branding agency to create the logo, then unless there's an agreement that assigns a copyright over to you, the branding agency will be the owner of the copyright. So it's very important to make sure that you have that signed over to you prior to applying for a registration for the logo. And I'll just pass back over to Pam for any questions.
Okay, I'm not sure if we have any questions yet. Let's have a look.
Sorry, I wasn't sure if we were allowed to ask questions yet. How early do you see fintechs trademark their, brand, etc.? Do they do that very early on, or do they wait for like an element of success, or is it just relative to different situations? Probably one for Jason, yeah.
Yeah, it just depends on the situation. I mean, typically, you'd want to be, you just need to think about the timelines. I mean, ultimately, you want to get the first application on file prior to using it. So you just need to think about the timelines and be thinking about the brands way in advance of filing the applications, and then factor in the fact that you will have to be conducting trademark searches prior to filing as well. The good thing when it comes to timing is when you file the first application, it gives rise to a 6-month period, a priority period, in which you can file in other jurisdictions. So this just enables you to spread cost a bit.
Perfect, thank you.
Okay, thanks for that question. Do we have any more questions? I can't see any in the chat box, but if anybody would like to verbally give their question or type anything into the chat box, please feel free. Well, I think that's probably us for now then. Thank you for attending or for watching this at a later date. And if you do have any questions that come to mind after we've gone, feel free to drop us an email or get in touch, and we'll be happy to speak to you on a one-to-one basis. Thank you very much.